Do you want to be represented by the public defender's office or not?
Well, again, I'll ask my question again. If we do
I'm not going to answer your questions. I just need to know, do you want to be represented by the public defender's office or not?
Well, in order for me to give you that answer,
okay, then you won't give me an answer. Here's what I'm going to do.
Here's my answer.
Counsel, no. Stop.
No,
stop.
I'm not allowed.
Right now, no.
Court calls case People versus Jade Latham.
Case on behalf of the people.
Overwater Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
Your Honor, I did attempt to...
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade, Ruth, and Lathan, and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation, this matter be set over for a competency hearing.
I'm not
pursuant
asking
to the
for
statute.
anything, and that's, I mean, from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay, I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for
June 6th.
June 6th, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order.
Court calls case People versus Patrick Petterprin.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Petterprin. Can you state your name, please?
Patrick Clayton Petterprin.
Go ahead.
Your Honor, Mr. Petterprin and the Public Defender's Office is kind of an impasse. He would like to withdraw his plea. We have no legal basis to do so. At this point, I think maybe new counsel needs to be appointed if he wants to do so, because we don't necessarily agree with that strategy.
Was this a felony that came down?
This is misdemeanor, I do believe.
Yeah, it was an OWI second.
And you're wishing to withdraw your plea, but defense counsel in good conscience can't file that.
They're saying that the only way that they would be able to file it would be via the ineffective assistance.
At this point, the courtroom dynamic changes completely. The defendant is trying to revisit a decision that has already been made, but the judge is looking for something much more specific, a valid legal reason, not simply second thoughts. Notice how the defendant keeps returning to the facts of the incident while the court is focused on procedural rules. That disconnect is what creates the tension in this hearing. Whether he truly has grounds to withdraw his plea remains unclear, and every answer seems to raise even more questions. The next exchange will determine whether this case moves toward sentencing or takes an entirely different direction.
And that is not exactly what I've been trying to say, but it's rather hard to do so. I don't want to waste the court's time. I guess I also don't want to waste my time. I've been in here about 6 months. So with that being said, I guess if I have a question as far as if I did file for the ineffective assistance to see where we could go from there. As far as my representation, would I be able to represent myself, or do I have to wait on representation from another firm that would do this pro bono?
Are you asking that? I mean, I don't know that a motion has been filed before the court for the withdrawal of the public defender. So they're still on the case, but I'm trying to figure out
And
what the issue is.
if Mr. Petiprin does not want to move forward with sentencing today, I think that's the only viable next step is for the public defender's office to withdraw, because we don't agree on the strategy moving forward.
Well,
Your Honor.
no, I understand that part. I'm just trying to figure out why. Or is there a basis upon which you're seeking to withdraw your plea, sir?
Yes, if I may, I have some notes here that I wrote down. I'll keep them brief.
Please.
All right. Now, I won't even go all over. As far as my desire to withdraw the plea, I have several things written down, but as I said, I'll try to keep it brief. For one, and I'd say the main, the fact that several of the gentlemen I was engaged with an altercation. Several of the gentlemen I was engaged with in an altercation on the night in question were moved to my blocks days, if not the night prior to my arraignment and or pre-sentencing, preliminary hearings, and so forth. Has to do with why I would like to withdraw my no contest if necessary. And to explain that, I would say that, I would say that being that it can be hard to communicate or even think, while being incarcerated and different things like that are things that would, make it hard for me to make the proper decision, but I did not plead guilty. And that's why I believe that the no contest plea it'd certainly be, I would feel, now granted, I have not passed the bar exam or anything like that, but I feel that it would be easier to withdraw a plea of no than a guilty or not guilty plea. That being said, there were other issues with the offense in general. As far as, like I said, it was, the offense is a driving or operating while intoxicated. And I was not in my vehicle. I did not have keys in my vehicle. I had not hit anything on the road that would indicate that I had caused a drunk driving.
Let me just stop you there.
Sure.
Because I'm not sure that these are forming. Do you want to be represented by the public defender's office or not?
Well, again, I'll ask my question again. If we do
I'm not going to answer your questions. I just need to know, do you want to be represented by the public defender's office or not?
Well, in order for me to give you that answer,
Okay, then you won't give me an answer. Here's what I'm going to do.
Here's my answer.
Counsel, no. Stop.
No,
Stop.
I'm not allowed.
Right now, no. Miss Attorney, your office makes a decision as to whether or not they want to withdraw. I'm going to adjourn the sentencing out, and you folks have to decide whether we're proceeding with sentencing or not, or whether or not he's going to file a motion to withdraw.
I asked if I could represent myself if they were taken off. You didn't answer that question for me.
They can explain that to you. Sentencing in this matter will be adjourned.
To what date?
February 14th,
What day?
2024. What time? 10 a.m. 10 a.m. Thank you. Bond
Thank you.
continue.
Thank you, John.
This hearing is a reminder that courtroom battles are often won or lost through procedure rather than emotion. One defendant challenged her identity and was ordered to undergo a competency evaluation, while another tried to undo a no-contest plea but struggled to establish the legal foundation required to move forward. Instead of dramatic rulings, the judge focused on protecting the integrity of the legal process and ensuring every step followed the law. Sometimes the biggest courtroom moments come from simple questions that never receive direct answers. What do you think? Should courts allow defendants to change their legal strategy after entering a plea, or should those decisions remain final unless there is clear legal justification?